we've had some issues with the technology. We've had some issues with the platforms. They obviously have their limitations because what we need as a profession are quite different to what a
Yes.
group of people might need if they just want to conduct a video call or a virtual meeting.
Mm.
It's going to be especially difficult to
Mm.
convince people about the efficiency gains and the cost effectiveness of ODR as compared
Mm.
to the old-fashioned way of doing things.
I'm Rashmita Das from Legal Observer, and today we have Advocate Rasib Chaudhary, who is an empaneled arbitrator with Asian International Arbitration Center and associated with Chartered Institute of Arbitrator. So today we will be discussing about the online dispute resolution, which is a new tool to the Indian judiciary. But before that, I would like to have a brief introduction about Advocate Chaudhary. Can you please tell us what has encouraged you in your journey as an arbitrator, that you had about your experience and the common problems that you have handled as an arbitrator? Yeah.
Sure. Thank you for the invitation to take part in this conversation. Um, Primarily, I am a practitioner of
Mm-hmm.
commercial disputes. I'm a
Mm-hmm.
partner at Arceus Law, which is based in New Delhi.
Mm-hmm.
And I overwhelmingly large part of my practice is advising and representing businesses in all sorts of commercial disputes, especially businesses in the energy and infrastructure industries.
Mm-hmm.
So as a firm, we specialize in that, and we advise all the contractors, all the major contractors, the project employers, and other stakeholders in projects.
Mm-hmm.
Now, as part of any practitioner's sort of
Mm-hmm.
repertoire of skills, I think
Mm-hmm.
they look forward to a day when they are also able to act as arbitrator. And that is something that has been a recent journey in my professional experience. And in the context of the last couple of years of COVID and COVID related constraints and restrictions on how we practice law,
Mm-hmm.
on how
Yes.
we practice the adjudication of hearings and the conduct of hearings,
Yes.
I think we
Mm-hmm.
as a firm, as well as we at an individual level, have had the opportunity, in some ways, forced on us to
Mm-hmm.
embrace, remote hearings and
Yes.
virtual hearings.
Yes.
So in that context, I think we have all acquired a fair bit of experience of what
Mm-hmm.
works and what does not work, and what needs to improve
Mm-hmm.
if remote hearings are going to be a more permanent feature of how we conduct hearings going forward.
Mm-hmm. Okay. So, as a part of consumer, as we may in ODR, one part is a company and the other is the consumer part. So, what has been the consumer behavior to this new tool, like the new process, and what has been the adaptability among them? So, can you please give us an idea of that?
I think it's been a mixed bag actually. I
Hmm.
think we've had some issues with the technology. We've had some issues with the platforms.
Hmm.
As you may know, the transition
Hmm.
from physical to remote hearing started well before COVID.
Yes.
There was a
Hmm.
perception within the profession plus within the industry that
Hmm.
perhaps efficiency and cost effectiveness
Yes.
meant
Hmm.
that having some hybrid hearings and some remote hearings was a good idea.
Yes.
But we lacked, and we still lack actually,
Hmm.
a bespoke electronic digital
Hmm.
solution
Hmm.
that is designed
Hmm.
on, ground up for
Hmm.
the legal profession. We've
Yeah.
had to, improvise
Hmm.
using the same tools that the world is using. So you have
Yes.
your Zoom and your Google Meets
Yes.
and other video conferencing
Hmm.
platforms. Now,
Hmm.
they obviously have their limitations because
Hmm.
what we need as a profession are quite
Hmm.
different to
Yes.
what a group of people might need if they just want to
Hmm.
conduct a video call or a virtual
Hmm.
meeting.
Hmm.
So I think I can speak for myself, of course, only, but I think we've had a mixed reactions or mixed
Hmm.
experience
Hmm.
of how video hearings or remote hearings, as we call them,
Yes.
have panned out. I think
Hmm.
because of what we do at Arceus Law is a lot of
Hmm.
document heavy, legally complex, and
Hmm.
certainly factually complex
Hmm.
disputes, which are very document heavy.
Hmm.
So I think we have experienced occasions where
Hmm.
sharing documents, presenting evidence electronically to the tribunal or to a witness has been problematic. So I think we look forward to a day where digital solutions designed for the legal profession is capable of dealing with these unique requirements that we as a lawyer or as a legal profession have. I can of course expand on some of my points if you like, but I'll just wait to to hear your next question.
Yeah. So as you said, you had a mixed bag of experience. I believe the main hindrance is due to the lack of knowledge. If we see that maybe many of the lawyers, they even did not hear about ODR. So and even for the customer, they're like it's for far thing for a layman. So there is a gap in between. So what is your idea as how we can fill this gap? What the government or as an organization, what we can do to fill this gap of knowledge?
I think you raise a valid point. I think education and awareness are a big step in trying to embrace, in trying to improve accessibility or awareness of ODR. I think the government is trying. I think the judiciary was trying to increase acceptance of ODR, to increase its awareness. But I think one of the issues has been that we still require a change in the mindset. I
Yes.
think I think people have a natural inclination to want to be with each other in the same room when they're conducting hearings, when they are presenting arguments to the tribunal. So that natural tendency as humans, as social animals, will not go away. So the fact is, today in a time when some might say it's post-COVID, or some might say it's post the peak of COVID. So as we reach an endemic stage of COVID, people are again very happy to meet in person. We are traveling again on work. We're traveling overseas to conduct hearings and so on. So in this sort of an environment, I think it's going to be especially difficult to convince people about the efficiency gains and the cost effectiveness of ODR as compared to the old-fashioned way of doing things, which was pure physical in-person hearings. I think one way in which we can make this more of a success is to show people, and by people I mean the end users. So you have your lawyers and your arbitrators, that what are the efficiency gains of using ODR. So, for example, it is more cost effective, certainly, to
Yes.
allow each individual to stay where they are, to stay in their base and log in and
Yes.
conduct a hearing. It's certainly more efficient because it removes the need to spend time traveling from point A to point B.
Yes.
But of course, there are some negative aspects which I think people are already experiencing, and therefore they are quite reluctant to embrace ODR. I think one of the issues, as I was mentioning earlier, is the effectiveness of presenting arguments on screen. It is the effectiveness of being able to judge the credibility of a witness.
Yes.
It's the ease with which I can connect to the arbitrator, or I can connect with the witness I'm cross-examining.
Yes.
Unless technology improves to make me believe that I'm as effective as an advocate online as I would be if I was in the same room as you,
Yes.
for example,
Yes.
right now,
Yes.
I will be quite reluctant to accept a pure remote hearing structure to an arbitration. I think there's one aspect of a hearing where I think parties can be really encouraged to embrace remote hearings, and that is procedural hearings that might be closing arguments, stages of the arbitration process, for example, where there isn't much requirement to engage with the audience, or to immerse ourselves amongst the audience as there would be, for
Yes.
example, if I was examining a witness.
Mhm.
So in these small ways, I think we can really embrace a sort of a mixed structure to an arbitration process where certain parts of the hearing are entirely remote and certain other parts are entirely in person. But there's always the option of allowing, for example, a witness to log in remotely, thereby make it a hybrid hearing. So it all depends on the need of the case, and I think we need arbitrators who are really aware of the issues, to have a conversation with the parties and their lawyers, to try to come up with a really bespoke procedural order to deal with the requirements of that particular case.
Exactly. Right. So as we know that, as you just said, that this is cost effective. This the ODR whole process is quite cost effective. So even if the law firms, like the individual law firms, even they encourage that, say, will it make much difference in their revenue model? Because how much is the burn rate? Because even say the lawyer who is putting effort into it, is it beneficial from the lawyer's part?
Yes, absolutely. I think what ODR does
Hmm.
mainly is that it cuts out the need for lawyers, arbitrators, witnesses
Hmm.
to spend time traveling from
Hmm.
point A to point B.
Hmm.
It cuts out the expenditure that
Hmm.
is incurred in flying,
Hmm.
the expenditure that is incurred in staying at hotels. Those
Hmm.
things are saved. So there's
Yeah.
a time saving. There's always there's also a saving of expenses. That should be a good thing because ultimately it is the clients, it is the parties
Hmm.
who invariably end up having to pay the bill for
Hmm.
hotels and flights. If those can be taken out of that equation, then I think
Hmm.
for businesses, for the parties engaged in a
Hmm.
hearing, it
Hmm.
must be a cost effective way or a more cost effective way of having their cases
Hmm.
conducted from start to finish.
Hmm.
But from a lawyer's point of view, from the arbitrator's point of view, it really makes no difference because, if anything, it's actually positive for
Hmm.
them because
Hmm.
they are not spending time, or should I say, wasting time
Hmm.
traveling
Hmm.
to another part of the country or
Hmm.
even the world.
Yes.
They could be spending that time, or at
Hmm.
least spending part of that time,
Hmm.
doing a productive work, doing
Hmm.
a billable work,
Hmm.
and that should have a positive impact on their professional earnings, their
Hmm.
fees.
Hmm.
So I think it's win-win-win for all the
Yes.
stakeholders,
Hmm.
the arbitrators, the judges, the lawyers, the witnesses,
Hmm.
the end users. The only two people who lose out are
Hmm.
probably the airlines and the
Hmm.
hotels.
Hmm. Okay. As you know, Singapore is almost being the hub of international arbitration. And if we see from the Indian part, India has a quite rich resource aid for knowledge, brain, or research. So, where do you see this Indian ODR in next 10 years, and what India can do to capture this international market? Because if we say for the international commercial arbitration, then India can have a good, what India can do to capture this market from Singapore.
I think we'll have to take some baby steps. I
Yes.
think
Mm,
first of all, I think 10 years is too far out
mm,
to be able to do crystal ball gazing. But I think what we can do as a jurisdiction is take
mm,
advantage of our natural advantages, right? We have a fantastic pool
mm,
of retired judges who
mm,
are excellent in what they do as arbitrators. They
mm,
have decades of experience in how to conduct adversarial proceedings, how to weigh up the probative value of evidence, how
mm,
to write judgments or arbitration awards.
mm,
So we have that excellent pool of arbitrators who can
mm,
be deployed. We also have a fantastic professional body of advocates,
mm,
and whether it's in individual practice or as part of a law firm. So I think we have the ingredients, the raw
mm,
material, if you
mm,
like.
mm,
Our judiciary is now extremely supportive of arbitration. It's become
mm.
extremely pro arbitration. I think it's fair to
Yes.
say there have been a series of
Mm,
judgments over the
mm,
last 5 to 10 years
mm,
where India as a jurisdiction is
mm,
being acknowledged as a pro arbitration jurisdiction.
mm,
So we have, I think, the building blocks of
mm,
what we will need to
mm,
make India an arbitration hub. Now,
mm,
when that will happen, how quickly that can happen, it's all a function of many policy decisions that the government can take.
mm,
It's also a function of people's mindset. It's a
mm,
function of how we conduct the arbitration ecosystem in terms of efficiency, in terms of tribunals being cost
mm,
effective
mm.
in how they administer a process. So I think we need to have a more detailed conversation amongst the
Yes.
stakeholders,
Mm,
and that starts from the government. It starts from the excellent pool of retired judges whom we have
mm,
as arbitrators, and of course
mm,
the legal profession itself.
mm,
Plus, you have other sort of
mm,
stakeholders on the periphery who also
mm,
play a part in the success story. So I think we have a lot of cause for optimism Or whether we actually see it at the end of the day or not, I think is going to be a function of many things coming together. And I think, I hope that as a jurisdiction, we engage in a more sort of detailed conversation of how to make that happen, of how to make that a reality in the coming 5 to 10 years.
Exactly. So, as you mentioned, that the government has to take an initiative, especially the retired judges. As we can see that Niti Aayog has recently worked on that, and they are further working on it. What are your suggestion? What the government more can do to encourage this ODR and in international arbitration, and as well as for domestic jurisdiction process?
I think, look, I think we have um, uh, we have excellent human resources, right?
Yes.
Now the question is that human resources on its own is not
Mm.
going to be enough
Yes.
to make this a
Mm.
reality. We do have a lot of ad hoc arbitration in
Mm.
this jurisdiction. We have a handful of good institutions who are doing an excellent role in
Mm.
promoting institutional arbitration. I was commenting to some friends in
Mm.
Singapore the other day that, look, you and other jurisdictions have had an excellent bunch of reasons why you've become a hub for arbitration.
Mm.
And I have recently written about this. I can just tell you a few of
Mm.
the
Mm.
important features or reasons
Yes.
behind the
Mm.
success of places like Singapore, Hong Kong. Access to state-of-the-art physical
Yes.
infrastructure for conducting hearings
Mm.
or for conducting, say, remote hearings,
Mm.
right? Availability of an excellent panel of arbitrators who have the requisite experience and expertise.
Mm.
A most recent concept of third-party funding
Yes.
has been brought into in Hong Kong and Singapore by way of legislation. India
Mm.
does not have any such legislation, but India does not prohibit
Mm.
third-party funding. So that can be a good thing
Yeah.
for encouraging India as an arbitration hub. We need judicial support, which we have now to a large extent.
Mm.
We need institutions, we need other bodies to do very efficient case management in order to make sure that the process of arbitration from start to finish is efficient, it's
Mm.
transparent, and cost effective. We also need to be able to be very agile in how we fine tune, whether it's our arbitration laws, whether it's our arbitration sort of case law or statute,
Mm.
whether it's the flexible rules of arbitration institution. All of these things are extremely important and play a vital role.
Mm.
Um, so all the features that I've just mentioned are actually a collective group of
Yes.
features, right? I mean, no one of the feature on its own is going to have an oversized effect on making India the
Mm.
seat of choice or the hub for arbitration. All of these have to come together, and some of them are in the control of the government, others are in the control of people like me who are part of the arbitration ecosystem. So it's
Mm.
very much doable. It's just that it needs more of a concerted, structured, organized
Mm.
push and some baby steps in
Yes.
order to make sure that 10 years from today, or even say 5 years from today, India is playing host
Mm.
to arbitrations not only in disputes arising out of India, but
Mm.
also is administering or is playing a seat role to arbitrations from outside India.
Yes.
I think that's the sort of the promised land, which we
Yes.
will see if it happens or not.
Yes. Because India already have resources, we just need to use it.
Yes,
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 absolutely.
absolutely.
Right. Uh, that was really insightful. Thank you, Advocate Chaudhary, for joining us and sharing this valuable opinion with us. And this was nice talking to you. Thank you.
Thank you, Rashmita, and thank you for inviting me to share my views. Always happy to offer my views.
Thank you. Bye.
Thank you. Thank you. Bye bye.